Cause number 41510 on Brian Casimir. Macon. Morning. Morning, Mr. Nichols.
Good morning, Ryan.
Good morning, sir. You Brian Casimir?
Yes, ma'am.
And Mr. Casimir is charged with the first-degree felony offense of murder. Mr. Macon, what is the announcement?
Your Honor, Mr. Coffin, my investigator, is having a very difficult time talking to the tenants of the, I'm having one of those brain things, Stonegate, was that it? Or-
It's a house on next week.
Yeah. And he requested an additional time if we could reset it a short period, and we'll be ready for trial.
Right, so any issues, Mr. Nichols?
No, Your Honor.
So I'll just reset it a normal 30 days for an announcement, and that should hopefully give him time to do everything he needs. And at that date, if there's a rejection of any plea offer, we'll take it that day and set it for trial.
Sure.
Or if there's something worked out, we'll take care of it.
Thank you.
All right, you can go back with the bailiff. Ma'am. Okay. Clause numbers 35338 and 35339 on Jacob Kozad. Well, he was found
Incompetent.
right again. Okay. Now we send him back again. All right, this is Jacob Kozad, cause numbers 35338 and 35339. Mr. Kozad has been here previously several times. There was an initial finding of incompetency back in April of 2022. Mr. Kozad was sent to the appropriate facility for competency restoration. His competency was restored. He was sent back. And since that date, Mr. Macon has had difficulty, it's my understanding, discussing and Mr. Kozad understanding what's going on and recognizing everyone. We had another competency stand trial evaluation done by Dr. Hamza. Going to take judicial notice of the court's file that's dated May 15th of 2023. Dr. Hamza makes the finding in this that Mr. Kozad is currently not competent to stand trial. Is there any other evidence with regard to competency, Mr. Macon?
No, Your Honor.
Mr. Smith,
I have something, sir.
what's that, sir?
Yeah, they called me down 3 times. I don't take medications. I don't claim to be mentally ill. I refused twice. Then they called me down again in person, tried to find me incompetent. I mean,
Well,
I'm not mentally ill, so why would I be incompetent?
well, based on the professionals, there's been a finding that you're not competent. You've had, at least in front of me on several occasions, you have not recognized your attorney, not understood what's going on. I don't have a choice based
The
on.
reason is whenever I first come in the county jail,
Mhm.
there's a program up front where you can telecom on camera and talk with a lawyer or whoever wants to speak with you.
Mhm.
James Macon, off 3rd and Broadway. That James Macon is a little bit bigger, jollier fella.
He's not. That is Mr. Macon. He might have been bigger and jollier at one point, but this is
So,
him right now.
I used.
Hang on. So listen,
I
I'm
also
gonna.
use James Ham out of that office, so I know who they are.
All right. So Mr. Ham hasn't been in that office in many years. He
I used
actually.
him in 2017. Got
Okay.
sentenced on DWI.
That's
I hired him
fine.
Out
That's
of that
fine.
office, 3rd and Broadway.
Perfect.
Yeah.
This is Mr. Macon. I can assure you, this man standing right in front of me is Mr. Macon.
I disagree.
Okay. then I'm making the finding.
He spoke with me on camera.
Listen, stop talking
Mailed
for a
me his
minute.
card.
I'm going to make the finding based on this evaluation from Dr. Hamza that Mr. Kozad is currently not competent to stand trial. I am going to order that he go to the appropriate facility for a period of not to exceed 120 days from the date he gets there. And then we'll await a competency evaluation from that facility. You can go back with the bailiff.
Thank you.
Yes, sir.
Okay.
I know.
I know.
Finding of a job.
And I don't know at this point if you're appointed,
Yes.
So-
No, I'm not.
you're hired.
Well, I didn't
think-
charge near enough. to say
Well,
the least.
and I don't know what you want to do. I'm not going to tell you what to do. Obviously, it may be beneficial if he's going to have this issue, seems to be a recurring issue, that you allow me to appoint someone, and that way he
Who's the
starts
biggest
fresh.
lawyer we have on the
We'll
list?
find someone jolly and,
Yeah, I'll talk to his father.
no,
John,
but
and-
really, just because that seems to be such an issue of concern for him that he's confused about, maybe if we just start fresh when he comes back. But talk to his family, talk to him, whatever, when he comes back, and we'll go from there.
Okay.
All right, thanks.
Yeah, if we can get him confident.
Cause number 39253 on Amanda Hurstman. Mr. Radford.
I'm jolly and big. I just got the
Hold on, we
media.
gotta get her. Good morning, ma'am. Are you Amanda Hurstman?
Yes, ma'am.
And Ms. Hurstman is charged with the state jail felony of fraudulent use of identifying information. What's the announcement?
Judge, I just got the media on this case. I need some time to go out to the jail and review it with Mrs. Hirschman.
State's not supposed to continue.
All right, well, I just reset it. Is there anything else that you're expecting as far as any discovery?
No.
All right, we'll reset it this one more time, give you some time to do that, get an announcement at the next court date.
Yes, ma'am, thank you.
All right, thank you. Go back with the bailiff. Yes, sir. Cause number 31545 on Amari Alexander. Morning, Mr. Smith. Morning, Mr. Wall.
Morning, Judge.
Good morning, sir. Are you Amari Alexander? And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Alexander, in cause number 31545, you're charged with the third-degree felony offense of engaging in organized criminal activity from January 10th of 2019. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Alexander is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of engaging in organized criminal activity. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived any right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Possession, because of the judgments entered against you, possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk to Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff. I messed it up. I skipped. I did. I knew it as soon as I did it, but if I try to start over, it's too early in the day for me to already be messing that up. I know, right? Clause number 38523 on Derica Johnson. Good morning, ma'am. Are you Derica Johnson? And good, thank you. Will your client waive the formal reading of the motion?
She will, Your Honor.
Ms. Johnson, in clause number 38523, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation March 7th of 2022 for aggravated assault, and that was a 6-year deferred adjudicated probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that you failed to provide verification of attending the ISF cognitive treatment track. And is that true or not true? Which one, true or not true? Count 2 alleges that you failed to provide verification of performing the community service hours as required. And is that true or not true? Count 3 alleges that you failed to provide verification of entering and successfully completing the anger management program as ordered.
True.
And count 4 alleges that you are behind in your court assessed fees.
True.
All right, ma'am, did you know your pleas of true to counts 1 through 4 freely and voluntarily?
Yes, ma'am.
And did you plead true to those because they're actually true?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am.
And did you fully understand them?
Yes, ma'am.
And do you understand if I follow this agreement that you are making with the district attorney, that you'll be waiving any right to appeal?
Yes, ma'am.
Also, I want to make sure you understand the reason that I'm going along with this, right?
Yes, ma'am.
So you've already had some issues on probation. You were ordered to go to ISF, but you are currently, or you're still pregnant, correct?
Yes, ma'am.
And so that they won't let you go there. But what I'm going to do, if I follow this agreement, I am going to order that I'll go along with it. You're going to get that upfront time. If you have any left to do, fine. If not, you'll get out. But you're going to be required to enter and successfully complete the JCDI program. It's an outpatient program. My main concern right now is that without the treatment that you needed to get, in my opinion, and in probation's opinion, from ISF, well, it was for cognitive. What was the allegations? Let's see. Any drug use allegations, or was it all just not showing up?
It was just reporting.
So you went to Louisiana. What were you doing over in Louisiana?
That's where I was staying at the moment.
So where are you going to live when you're released?
At my mom's at the 1898 address.
Here in, I want to make sure you understand if I follow this agreement, you leave town, you're not supposed to, you don't go to the classes or anything. I'm not going to order JCDI unless the probation department feels like that's an issue. But I'm going to place you on the high medium caseload. That means you're going to have to go a little more often. And if you don't follow any of those agreements, yes, ma'am. She is already. So this is your opportunity, pregnant or not, baby or not. All right. They have hospitals that they can take you to in prison to have a baby. And that's what's going to happen if you don't follow the rules. No one wants that. I don't want you to have your baby in prison. But if you don't follow these rules, you're not going to give me any opportunity or choice to do anything else. Right. All right. So state tenders number 1.
No objection.
It's admitted. Any evidence that Ms. Johnson's not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1, 2, 3, and 4 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty. However, and revoke your probation. I'm not going to do that. I'm going to follow the agreement that you made and order that you serve 120 days upfront time. You will receive credit on that time for any time that you've been in custody, just on this MTRP, not from the beginning of the case. So again, if you have any time left, you're going to have to sit and do that. Otherwise, you'll be released. You're back on probation, do everything you're supposed to. You're still on a deferred probation. You don't have a felony conviction on your record. You can be successful, ask probation for any issues. If you need to leave town, you have to ask permission. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived any right to appeal. You can go back with the bailiff. Good luck to you.
Yes, ma'am. Thank you.
Yes, ma'am. Cause number 41413 on Andrew Michael.
Okay, send in the discovery printout.
I feel like I should be going down and looking at this for something like we had talked about, but I don't know what I would be doing it. Like those MTRPs and stuff, you know. Just fine. Good morning. Are you Andrew Michael?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
She will, Your Honor.
Mr. Michael, on cause number 41413, you're charged with the 3rd-degree felony offense of unlawful possession of a firearm by a felon from October 31st of 2022. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? So if I follow the agreement, you can't change your mind later. Do you understand?
Yes, ma'am.
And do you also understand if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1,
No objection.
it's admitted. Is there any evidence that Mr. Michael's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of unlawful possession of a firearm by a felon. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. This will run concurrently with cause number 16-25557. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived any right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. You obviously know this at this point, but I'm required to read this to you. Because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to your attorney. All right, good luck to you, sir. You can go back with the bailiff. Mr. Burbank, cause numbers 39958, 40031, and 40032 on Roderick McKinney. Oh, is this a,
Still waiting sentencing.
okay,
Next story, I don't think they brought him over yet.
okay,
We would like to bring them over before sentencing. The deal has been cut over there. We have an offer from the state. Love to take care of it so that he doesn't get in the mess of TDC and federal who takes him back.
so you want them to get over here and play on these sooner rather than later? Why don't we reset
1
this?
week.
Yeah, let's reset it a week if you guys can get with, Brandon's been great about figuring out how to get them over
Yeah,
here.
he's good at that.
Yeah, so, let's see if we can get them over here, next
We
Tuesday.
have an offer, so we've got also a plea offer in the feds. Just waiting for something.
All right, let's just see if, he can get them over here for next week,
Thank you, Your Honor.
because you'll have to do, the writ and all that. All right, thank you, Mr. Burbank. Is that all you have? No, cause number 39658 on Markeith Morgan.
Judge, this case had originally been on the trial docket. Kind of due to my real suggestion, we took it off to try to work it out. Been able to really get where Mr. Burbank wants.
Okay,
So my only real suggestions we put back on trial docket will be ready to go.
Did file a motion earlier for a bond reduction.
You did. the offer still 40.
I think we rejected 10 last time. Making that up.
I don't have anything other than that. now. Good morning, sir. You Markeith Morgan. And Mr. Morgan's charged with the first degree felony offense of murder from August 6th of 2020. So it's my understanding that the announcement is that there has not been anything reached as far as an agreement. And Mr. Burbank, you're requesting that it go back onto the trial docket. Is that correct?
We are ready to go.
Okay, I just need to know what that new offer was before we go
I thought it
forward.
was like 10 or something like that. Is that not correct, Mr. Burbank?
I don't remember 10, but I would ask.
All right, I'm gonna hold it. Y'all figure out what the offer is so that I can write it down because I need to admonish him about that and then we'll have the bond hearing as well.
Judge,
Yeah,
these guys, okay.
I mean, whatever it is, it's fine. I just need. Mr. Lewis, does he mind? Mr. Nix, good morning. Are you, looks like you've got a tablet. Are you working on Anthony Johnson?
Yes, Your
I'll
Honor.
hold it.
One's going to be a plea, one's going to be a dismissal. We haven't signed up for the next 5 minutes.
That's fine. I'll hold it till it's ready.
We
Thank you.
reindicted that charge, Judge.
Oh, gotcha. Perfect. Thank you. Mr. Parker, cause number 41562 on Kavan Cameron or Carmen, I'm sorry.
It's hard to read. One little paragraph says, no.
I know,
Yes or
you
no?
have to look for it. My staff does this for me.
I thought Makis was gonna be, fine. And then he started saying, I was like, oh my God, I mean, he sounded fine.
I know.
Because you want to see something back.
Carmen. Carmen.
He's not confident.
Right, he may not be paying, he's got to be back there somewhere, right?
Last name is Carmen.
Or Kevon Carmen.
I looked it up one
He
time. I
keeps
couldn't
saying
find
it wrong. Like it's bad enough that at least say it right.
Well, how do you say it?
It's C-A-R-M-O-N.
Oh, Carmen is saying wrong. I thought you said
Carmen.
keep on wrong.
I mean,
Kmon
if
or
we've got
Kevon?
someone that's not competent, we at least need to try to get on, say the right name. He's back there going, it's not me. Yes, I'm sure. This one, yes. All right, this is cause number 41562 on Kevon Carmen, charged with the third-degree felony offense of harassment of a public servant in a correction or detention facility. I'm going to take judicial notice of the court's file, which includes a competency to stand trial evaluation that was done by Dr. Hamza dated May 11th of 2023. With the finding that Mr. Carmen is currently not competent to stand trial. Is there any other evidence with regard to competency?
No, Your Honor.
Nothing from the state judge.
All right, then based on that recommendation and that report, I am going to find that Mr. Carmen is currently not competent to stand trial. Find that the recommendation is he have inpatient psychiatric treatment in order to regain competency. I'm going to order him to the appropriate facility for a period of not to exceed 120 days from the date he gets there in order for competency restoration, and we'll await a report from that facility. You can go back where he can go with the bailiff. Yeah, give me just a second. Yeah.
He's accepted the offer of 10 years to robbery.
Okay.
But he's going, it's not a lesser included of murder, so they're gonna have to either file a waiver.
We're gonna have to re-indict. him.
Reindict
To be
it. We're
honest,
not,
I don't
no
know how
more
we would
waivers.
do a
We
waiver
don't,
at this
no,
point.
we're not doing waivers.
I don't
No.
think I ought to see the waivers.
Everybody's gonna lose their, they're gonna fall out if we, that's
We
not
reset-
happening.
We reset a couple,
2 weeks.
yeah, I won't actually be here in 2 weeks.
Well,
but-
am I?
I don't know.
Because I have, is it 3 weeks when I'm not here? Huh? How about a normal reset?
That would be fine. We'll get it done, Judge. Tom has better things to do, but.
2 year, 2.5 years.
I mean,
He's
if
not
y'all,
been in for 2.5 years. Also, it's like 2.5
He's been in for
years, year and a half,
2 something.
year and a half.
He was in long.
anyway,
Anyway,
we'll
We'll get
just do a
reindicted.
normal reset for a
Thank you.
re-indictment. Thank you. We're resetting, Markeith Morgan. And that can go in the plea docket. Ms. Holmes, you working on some, or you want me to just start? Okay.
I think that's two with- Oh, where'd she go? Oh, with Mr. Lesniak, one's a bond request, and then the other is Miss Kirsten, she's a co-defendant. We're waiting, she's gonna be participating in the co-defendant's trial.
Okay, I see that. When are those set?
One is,
Just looking at that, order, one of them's
Ah.
October. That's Ryan, but I think it's, is it Jalen?
Jalen is
And that's first, had to appoint him when they were done, and it's odd when it's set like June sixth.
And that's the one that's supposed to be going first,
that's the one I-
June
Yes.
6th. Okay. Oh, so. All right, so let's just reset. That's not the one you have the bond on.
No, no.
No, so we're gonna reset Kirsten Lewis. And I would say at this point, just let's make a notation. No, it's fine. To put it after, at least after, yes. And then if it needs to move, it can move after that one as well, if he's not ready. That may be one he needs to get busy on. Okay, and then you have
Archangel.
Yes, he doesn't, he never had a bond. He's been sitting with no bond.
Cause number 38480 on Ricky Archangel. Why doesn't he have a bond?
I don't know.
No bond. Iberia Parish, they did the whole out of state, no bond.
He's been here a while.
I mean, unless there's a hold, I don't think so, but on this, it just shows no bond.
We got him in custody, it looks like from Iberia Parish in April, but we were looking for him. 6 months ago.
But they're not supposed to no bond them just because they come from another facility. All right, are you Ricky Archangel?
Yes, ma'am.
And so, Mr. Archangel, I don't even, is there a motion? you filed a
I did,
motion?
it was filed Friday. So I
No.
saw it.
Hold on, hold
Yeah, it was
on,
filed
let's just
Friday,
see,
but I don't know when they accepted it.
let's just see.
I gotta check my email to see if they accepted it.
They did.
It's here, it's here.
Okay.
I've got it, you don't need it.
But I'm gonna-
I've got it, man. I don't know, can I sign the order? No. I can. And I can text box if I need to do. Well, we're gonna try it. All right, sir. You're charged with the 3rd-degree felony offense of failure to register with sex offender requirements, and that indictment alleges prior offense out of Louisiana. My understanding is that you were transferred here on a bench warrant from Iberia Parish. Is that correct?
Yes, ma'am.
All right, and Ms. Holmes has filed a motion for me to set a bond. There was not a bond set when you got to our jail. Is that correct? Do you have a bond? You don't have a,
No, that when I came, that Thursday, that Monday, when the judge had set me a bond for 10,000.
okay. Is there a bond set?
And then that's.
I see, and I saw that
So he was
somewhere.
told he didn't have it.
Yeah, after the judge had set me a bond, had been like 2 months, I didn't have no bond.
And I did check the jail screen and it didn't show a bond.
I mean, here's looks like. And here's a form I don't know that I've seen, but it looks like it's an Article 1517 appearance from Jefferson County, bond set $10,000 on April 21st of 2023. Signed by, I'm guessing that's Judge DeRuin, but it kind of looks like all of our signatures. Can you tell?
For sure.
Yeah. So you were magistrated and set a bond, and then somebody at the jail said no.
Wow.
All right. Well, I guess my thing is, let's do this. I mean, a bond's already been set. I'm going to. Yeah. No, I'm gonna do I'm gonna grant the motion, and I'm just gonna set it at what Judge DeRuin set it at, but I am going to order some additional conditions. Obviously. Ms. Lesniak, as far as conditions go, I know that,
The state's concern, Your Honor, in this case is obviously the nature of the allegation is that he wasn't following the rules, so we would want a GPS or something to make sure we knew where he was.
absolutely. And where do you live?
In Lieutenant General, every 3 months I go see the TO over there.
Every 3 months?
Yeah, but they had seen him made it feel, but they called me and told me I was locked up.
Mhm.
So whenever I get out, I have to go see, come to him.
Give me just a minute. Let's see if I can figure this out. Add a text annotation, right? Sounds like what I should do with it. We're gonna practice this some other time. So. Did it before, but there's more. I gotta figure out how to write in where it's signed on and the amount and my signature. So we're gonna, let's see, today's the 30th. All right, so I'm going to order as a condition of the bond that you are required to wear a GPS monitoring device at all times and that you are to remain, so what parish do you live in?
Send me,
St. Mary?
yes, ma'am.
I mean, Ms. Lesniak, what's your position on letting him return there with the GPS or not? I don't,
I guess I would ask, I know one of the reasons that he stated he didn't register properly was that he had a case in Louisiana that a warrant was out for. I think I would want to know what the status of that.
do you have any other, do you have any other cases pending right now?
No, ma'am. All I do, they go see him every 3 months. You know, I go every 3 months.
Right, well, obviously there was some type of issue because they,
What do you see? I'm sorry, it's not my question.
well, I mean, I guess,
I think parole. Is it parole? that you're-
who do
No,
you
I'm not
see?
on parole.
You're not on parole?
No, I just, you know, I have to.
You have to register every 3
Every 3
months.
Yeah, go see him there. Report to him.
I guess the issue is where is he supposed to be reporting, registering? Because
Well, then maybe we can make registering properly as a condition of his bond.
in the indictment, it's alleging he didn't register property in Port Arthur.
Right. He was here,
But
he didn't register.
If he's not here, then he needs to be registering somewhere else, and whether he did or not, we need to find out. Okay. I'm going to require, obviously, as a condition of your bond, that you register properly wherever you are living. Within, I mean, 3 days of release, you need to,
Yeah, I'm in contact with his daughter, so I'll make sure that his family gets that information as well.
so wherever you're living, they need to know where you are, and it needs to be done properly. You should have been, it looks like, I mean, the initial case that you had to register for is from 20,
He's been registering, I think,
Since-
correctly since 2015. So earliest registration dates for him.
before that, because there's another failure to register June 12th of 2012. So whatever that underlying offense is was older than,
Yeah, I think it was back in the
He was
90s.
92.
okay. So obviously this isn't something that's new. All right. All right, and then if you make that bond, be sure and stay in touch with Ms. Holmes. You're also, if you make that bond, I want to make sure you understand up front that I do expect you to attempt to hire your own attorney so you can start that process. If you can't afford one, then we'll discuss that at a later court date about Ms. Holmes. But typically, if someone makes a bond, I require them to at least attempt to make contact with attorneys and see if they can hire one. Okay?
Yes, ma'am.
All right, you can go back with the bailiff. And put that on my desk so we can figure out what happened, why there was or okay. Mhm.
Want to get a reset. We're gonna bring her up here.
What is it?
We want to get a reset. I'm gonna bring her up here.
Yeah. Who is it?
Ms. Garrett.
Calls number 41454 on Rachel Garrett.
Oh, you want it?
All right, ma'am, are you Rachel Garrett? And Ms. Garrett's charged with a state jail felony offensive theft of copper, bronze, or aluminum wire from October 27th of 2022. The indictment alleges several prior offenses. And what is the announcement?
Your Honor, we're requesting a little time. There's an issue. She says that she can prove her innocence if she has access to her phone and what's it called? iCloud. And I think that would make a big difference. And if what she says is accurate and we can provide that, I think the case will be dismissed. But the other issue is she's in jail on improper bond, but I don't know if the court was aware when she missed court because she went to Orange County to sit out some traffic tickets. She was in Orange County whenever her court date was here. I think her original bond was at 6,500.
Did you file a motion for me?
I did not. I just learned of this, Judge.
Okay.
But I want to make the court aware of it.
I do have a notation that looks like she was in Orange. On that court date.
She thought she would be out. She was sitting out traffic tickets and she thought she'd be out in time for her court, but it ended up being more expensive, or meaning more days than she thought is why.
Mr. Coleman, what's your position on me reducing the bond?
So they have no reason to doubt what Mr. Parker is representing under those circumstances. Judge, I defer to the court.
The original. 6,500. You have any other warrants anywhere, issues that you're gonna need to be dealing with if I do this? All right, so let's do this. I'm going to reduce Ms. Garrett's bond to $6,500. Just based on some of the criminal history that's alleged in the indictment, I am going to require as a condition of that bond that Ms. Garrett, that you have a drug patch put on. And so you'll need to get that done within 24 hours of your release. Your bondsman can let you know where you need to get that done. Obviously, stay in touch with Mr. Parker. Once you get that information to him, he'll get it to Mr. Coleman. And we'll get an announcement at the next court date.
So, Matt, if I may, so would my bond just be reinstated because I was out, my bond was paid? So I
That's
could
gonna,
just go
I'm not
back through?
necessarily reinstating it. I'm reducing it to that amount. You can talk to the bondsman that bonded you out and sometimes they will work with you on that. All right? You can go back with the bailiff.
Thank you.
Yes, ma'am. Mr. Wilkerson, cause number 41415 on Isaiah Fuentes. Morning.
This was Miss Lesniak's, but I know she had to leave, so I'm not sure. if there's coming up.
Fuentes, Isaiah Fuentes. You want to cause number? Got it. Morning, are you Isaiah Fuentes? And Mr. Wilkerson, what is the announcement?
Your Honor, there was a kind of a modified offer extended Mr. Fuentes. He, however, wants to pursue trial. in this
Okay.
matter.
In the offer that I had, so we went through this before, Mr. Fuentes, the indictment, and as alleged with that prior. I'm not sure why, when we went through this before, it's a second degree felony and it shows one prior, but there was some notations on the plea bargain rejection that it was habitual. Is there,
Yes, Your
were there
Honor.
other offenses that were given notice that are not in that?
They haven't
indictment?
been formally noticed yet, but we have been made aware of them and provided a
Okay.
prior judgment.
Okay.
So
So we went through that before, that if you're found guilty and those prior offenses are found true, you would be considered a habitual offender with a minimum punishment of 25 years up to 99 years or life. The previous offer that was made that you rejected was to proceed on count one only, which is that second degree felony for a 20-year term in the institutional division. What is the offer that's been made at this point?
we would be similarly pursuing only on count one. It would be a cap of between 15 and 20.
What do you mean a cap? of
Just say
15?
cap of 15, Judge.
Okay. So I'm sure you've gone over with Mr. Wilkerson what that means. If you wanted to enter a plea of guilty, you could leave your punishment up to me. If I followed the agreement, I could not give you more than 15 years in prison. I could give you 15. I could give you all the way down to 2. You have every right to reject that and go ahead and have your case set for trial. I just want to make sure you understand what your options are.
What about if I go ahead and take that?
If you want to take that, we can get that taken care of today. So what would happen, let me explain the process. If you wanted to enter a plea of guilty today, you could do the paperwork for that. I would accept the plea or I would take that plea agreement and then I would reset it for sentencing, just so that I can get a pre-sentence report, get more information, anything that you think is important for me to know. Mr. Wilkerson get that information. He would present it to me on your behalf when we come back for a sentencing hearing. The state would present any arguments they have, and then I would make my decision on that date. Is that what you want to do?
Yes, ma'am.
All right, then I'll hold it for paperwork. Clause number 23 DCCR 0455 on Anthony Johnson. Got it. Yes, ma'am. Did you have your discovery certification?
Yes, ma'am, Your Honor.
Good morning, sir. Are you Anthony Johnson?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Johnson, in cause number 23 DCCR 0455, you're charged with the first degree felony offense of aggravated robbery from December 28th of 2021. And how do you plead to that charge?
Plead guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Nix?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
My understanding of your agreement that you've reached is a 10-year deferred adjudicated probation, $1,000 fine, that you'd be required to follow any and all conditions of probation. And there would be, obviously, the case that was re-indicted from would be dismissed, which is 39072. Is that your understanding?
Yes, ma'am.
Do you also understand, if you are not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Johnson's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent. Do you understand the nature and the consequences of your plea?
Yes, ma'am.
Find sufficient evidence to find you guilty, but I'm going to reset your case so that I can get the probation department to do a pre-sentence report. That will give me more information about you and your case, and we'll come back at a later date for sentencing. Mr. Nichols, what is the state's position with regard to a bond based on the nature of the plea agreement?
I don't have any objection to that, Your Honor. He served close to a year and a half in jail. and he was cooperative with this investigation. Your Honor.
So what I'm going to do, Mr. Johnson, based on the nature of your plea agreement, is reduce your bond in your case to $2,000. There's a couple things that are very important if you make that bond. The very first thing, if you make that bond, that you do is go straight to the probation department so they can start that process for that report.
Yes, ma'am.
If you don't do that, then when you come back, you run the risk of me not accepting the plea agreement. Things could be much worse. Do you understand?
Yes, ma'am.
Also, if you make that bond and you're arrested for anything between now and when you come back, you run the risk of me not accepting the bond and things being worse. Do you understand that as well? Is there anyone, as far as a no contact, were there any?
No, there's nothing that
co-defendants?
needs to be done in that regard, Your Honor.
Okay, so we will see you back at sentencing then. All right. Thank you.
This is what it looks like on the new one.
If you want to go ahead and get them to sign that top sheet before they take them back,
Perfect.
and then you can fax over the rest.
Okay, perfect. Thank you, Judge.
Yes, sir. Thank you. Mr. Lewis, cause number 40360 on Jesse Kimmy. Okay. Good morning, sir. Are you Jesse Kimmy?
Yes, ma'am.
And Mr. Lewis, will your client waive the formal reading of the
He
indictment?
does.
There's a statement way paragraph 3. 220.
Mr. Kimmy, the state's elected to proceed on counts 1 and 2, which allege you committed the third-degree felony offense of failure to comply with sex offender registration requirements from December 20th of 2021. And then count 2 alleges that you were previously convicted of deadly conduct, discharge of a firearm, a third-degree felony, February 1st of 2006. And how do you plead to that charge?
Yes,
And is that prior offense true?
yes, ma'am.
Are you entering your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? The documents on that computer tablet, did you go over those with Mr. Lewis?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney, you will be waiving or giving up any right to appeal?
Yes, ma'am.
And do you also understand if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1,
No objection.
it's admitted. Any evidence that Mr. Kimmy is not competent?
No.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of failure to comply with sex offender registration requirements. Find that prior offense true. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived any right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. firearm is a legal term, and you should read that written admonishment to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk to your attorney. All right, good luck to you, sir. You can go back with the bailiff. I've only got one left of these, or two left. That's cause number 41568 on Adrian Lakey. Mr. Lewis. This is Miss Lesniak's, and it's a bond hearing. Is she going to come back down for that?
I don't know.
See what you did today. It's perfect. Good morning. Are you Adrian Lakey? And Mr. Lakey is charged with the first-degree felony offense of aggravated sexual assault of a child in cause number 41568. And that's from December 16th of 2022. It looks like the state has also filed a notice of intent to enhance the punishment range for the defendant with proof of a prior felony conviction. That conviction was burglary of a habitation from February 19th of 2002. And then okay, it's just that one. All right. And so that would make this, for punishment purposes, enhanced with a minimum 15-year sentence if there was a finding of guilt. Mr. Lewis has filed a motion asking that I reduce your bond. It's my understanding the bond is currently set at $250,000. Is that correct? Mr. Lakey, would you please raise your right hand? You swear the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? All right, thank you. Go ahead, Mr. Lewis.
Well, Judge, as you said, this bond in this case is $250,000. My client has been in custody this entire time, unable to make that bond. He does have family here locally that could have some resources to try to help him, including his father. My understanding is that's where he would be living locally with his father. He would not have any contact, of course, with the alleged witness in this case, which I'm sure would be a bond condition as well. I believe the court has some conditions available that would be able to help ease any concerns of the public safety or the safety or any concerns with the alleged complaining witness, but still allow him a lower bond, a reduced bond amount to allow him to be able to make bond, be able to help provide for himself as well as be there in support of his father, I believe, who he'll be living with. We are asking that the bond be reduced to 100,000 in this matter. I think that'll be, we believe that would be sufficient. In addition to GPS monitoring and a drug tax, because according to the allegations, he was under the influence at the time of this allegation.
All right, thank you, Mr. Smith. What's the state's position?
State is opposed in this case, Judge. I believe he had a prior felony revocation for burglary. You got 10 years TDC. The instant case here, Mrs. Lesniak's note said 25 to life, but I believe it's going to be 15 to life, as you recited. The victim in the case is a 2-year-old with acute tear, and this was definitely a crime of opportunity. We feel like bond is sufficient at 250,000.
As far as where you are in the discovery process, it looks like we've gotten the DFPS already, which is a good thing. And where are y'all as far as any type of rejection or offers or?
As right now, we're talking with the state. There was some DNA testing that we just got results in. I want to say Thursday, Friday of last week.
Okay.
But she was requesting additional testing on those. I have talked to her this morning about timeline wise, how long she was suspected. Those results will come back. And as of right now, we're looking at about a month and a half from what she's saying.
as we're potentially getting those results back.
Right, at this time, based on the allegations, I have also taken I am going to take judicial notes of the court's file. Very short, obviously, probable cause affidavit, but have reviewed that in the arguments of both. I am going to find that the current bond is appropriate in this case based on the nature of the allegations as well as that prior offense and the range of punishment. And I'm going to deny that bond request to be reduced. As soon as you get that information, we'll obviously set it, if it's going to be a trial, as quickly as possible, or if something gets worked out, we'll take care of it that way. All right, you can go back with the bailiff. So looks like Ms. Holmes is working. Mr. Wilkerson, you're finishing up yours.
Yes, Your Honor. I just sent it to you first.
Okay. And then we're waiting on Mr. LeBlanc's coming from another county. And so it's just Ms. Holmes and Apple. Perfect. That's the one that we reset because they have to re-indict it. They've reached an agreement.
Thank you.
But they're going to re-indict it. And so we were just going to do a normal reset, I think, because of everyone's schedule. And on the plea docket. Yeah.
Thank you.
Okay, clause number 41415 is recalled on Isaiah Fuentes. 41415 is recalled on Isaiah Fuentes.
That we're waiting for now.
Yeah,
She's
you'll
gonna
just get it.
email
Okay.
Oops, it's 30th. All right, are you Isaiah Fuentes again? And will your client waive the formal reading of the indictment?
Yes, Your Honor.
And are we going on count one only?
Yes, Your Honor.
Mr. Fuentes, the state has elected to proceed on count one only and alleges you committed the second-degree felony offense of aggravated assault from June 25th of 2022. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Wilkerson? Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney, you will be waiving or giving up any right to appeal? And we've talked about already what that agreement is, which is a cap of 15 years in the institutional division of the Texas Department of Corrections. Again, it just means you're leaving your punishment up to me. If I follow the agreement, I cannot give you worse than 15 years. I can give you 15, I can give you less. It'll all depend on the information that's brought to me later at a sentencing hearing. You have an absolute right to have a jury determine 2 things. The first is if you're guilty, and then you could leave your punishment up to them if they find you guilty. Going forward this way, you waive that right. And is that what you want to do? All right. And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Fuentes is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty to count 1 freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case, so that the probation department can do the pre-sentence report I talked about. And then we'll come back later for sentencing. Anything you think is important for me to know, get that information to Mr. Wilkerson. He'll present it to me at that sentencing hearing. All right, we'll see you back at sentencing. Thank you,
Thank
Mr.
you, Your Honor.
Wilkerson. Clause number 31672 on Keon Hury. Good morning. Are you Keon Hury? And you have your discovery.
I do have to print out the.
That's fine. You can send that this afternoon if you don't
Okay, yes,
mind.
ma'am.
Will your client waive the formal reading of the indictment?
Yes, Your Honor.
Hury, you're charged with the state jail felony offense of theft with prior theft convictions from January 9th of 2018. The indictment alleges you were previously convicted of theft July 13th of 2016, and then again October 4th of 2016. And how do you plead to that charge? And are those prior offenses true? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes.
And this is the one that you told me about where it was indicted after he'd already gone. All right. Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Hury is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of theft with prior theft convictions. Sentence you in accordance with your agreement to a term of 84 days in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Did I print it? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived any right to appeal. I'm also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to your attorney. All right. Good luck to you, sir.
Thank you.
Clause numbers 40546, 40547, and 40779. Called on Michael White. You got a notation of all of them that you're going to need to get.
And Judge, this is one where he was found not competent, but was found to be competent now.
Okay. I've got a sticky on. So 40546 is the one that's going to be dismissed.
You should have a dismissal.
And so where's the new competency? Okay. Are you Michael White?
Yes.
And I'm going to take judicial notice of the court's file. In each case, it includes that Mr. White was previously found not competent to stand trial, was sent to the John Dunn Behavioral Science Center for competency restoration. I have received a report from them dated March 3rd of 2023 that has the finding that Mr. White is currently competent to stand trial. Is there any other evidence with regard to competency, Ms.
No, Your Honor.
Holmes, Mr. Smith? Then based on that, I am going to find at this time that Mr. White is currently competent to stand trial. Will your client waive the formal reading of the indictment in each case?
Yes, Your Honor.
Mr. White, in cause number 40547, you are charged with the state jail felony offense of burglary of a building from June 26th of 2022. And how do you plead to that charge?
Guilty,
Are you pleading guilty freely and voluntarily?
yes,
And did you actually do what they charged you with?
yes.
And then and cause number 40779, you're charged with the state jail felony offense of unauthorized use of a vehicle from August 9th of 2022. And how do you plead to that charge?
Guilty,
And are you also pleading guilty freely and voluntarily?
yes.
And because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? The paperwork that was on the computer that you signed? Did Ms. Holmes explain that to you?
Seen in my signature,
Right. Did she explain what you were signing?
is for trial.
Well, for not for trial, but for me to accept a plea agreement. Is that right? Okay, so it looks like from this paperwork that you signed with Ms. Holmes that the agreement that you've made is for a 12-month term in the state jail prison, but you would get credit for all the time that you've already been in custody. Is that what you understand?
Yes,
So the time that you were in, even when you went to the hospital, that'll all count as credit. Do you understand? You do?
yes,
All right. Do you also are you a US citizen?
yes.
All right. State tenders number 1 in each case.
No objection.
It's admitted. Mr. White, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Again, make that finding that you're competent and you understand the nature and the consequences of your pleas. In cause number 40547, I'm going to find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of burglary of a building. Sentence you with, in accordance with your agreement, to a term of 12 months in the state jail prison. You will receive credit for any time that you've been in custody that the law gives you the right to receive. And cause number 40779, I'm also going to find sufficient evidence to find you guilty, and at this time, find you guilty of unauthorized use of a vehicle. Sentence you in accordance with your agreement to a term of 12 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. And I will sign a dismissal in cause number 40546. I'm handing you in each case the trial court certifications that shows that these were agreements that I followed, and so you've waived any right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. All right, you can go back with the bailiff. Good luck.
Thank you.
Yes, sir. Cause number 41372 on Patrick Brown. All right, so are you Patrick Brown? And will your client waive the formal reading of the indictment? Mr. Brown, in cause number 41372, you're charged with the state jail felony offense of unlawful disclosure or promotion of intimate visual material from November 29th of 2022, and how do you plead to that charge? Excuse me, are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And do you also understand, if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Brown is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of unlawful disclosure or promotion of intimate visual material. Sentence you in accordance with that agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. That will run concurrently with misdemeanor cause number 334120. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived any right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk to your attorney. All right, good luck to you, sir. Clause numbers 40832 and 41326 on Mark Davis.
That's one we should need some more time. Needing to pay me.
So I guess Frank Adams was on it and then they hired you? or-
Yes.
Okay.
It may not be in there.
Oh, yeah.
Okay.
If she knew how to look for it.
Yeah, I know.
You're Mark Davis?
Yes, ma'am.
All right. And so, Mr. Davis, it's my understanding that your family has hired Ms. Holmes to represent you. She obviously needs a little bit of time to get caught up, come visit with you, visit with the district attorney. So I'm going to reset your case, just a normal reset, to give her some time to get all that taken care of.
Mhm.
And we'll see if we can get an announcement at the next court date.
Okay.
Okay? All right.
So,
I don't know what it is yet, but it'll be in about 30 days unless something happens before then. You can go back with the bailiff.
okay.
Thank you, Judge.
Yes, ma'am. Thank you. Is the probation officer going to be here? Okay. Cause number 35862 is called on Dylan Reynolds. All right, you are Dylan Reynolds. And so Ms. Reynolds is currently on probation for the state jail felony offense of theft of a service. And let's see. It looks. There must have, no, I don't see the paperwork. Administrative hearing stuff. Let me find it. I don't see it in there. How do I go back? Hey, how do I go back to the docket? Exit. Y'all just give me a minute. I'm gonna try to figure this out. Oh, I don't know if I meant to do this. I don't know. No, I clicked on the wrong thing apparently, and I don't know how to just, and that takes me back just one thing. See, that's all I need. That's okay. I don't see an administrative hearing. It looks like there might be more things and I clicked on something and it took me somewhere else. View more events, view more hearings. Maybe it's hearings that I need to click on. It should be an event. See, when I went to events, it was, looks like there's just more to it. Because I see here on February 7th of 2023, there was a continuation and modified special condition for safety. I need what came before that. Let's see. Maybe I just missed it. Was there an actual administrative hearing that was done?
Yes,
And back in February?
yes.
Can I see a copy of that, please? So February 2nd of 2023, I was sent an administrative hearing that had the allegations that Ms. Reynolds had failed to report October, November, December, and January as directed, that she had not provided information about employment, that she had tested positive for methamphetamine, amphetamine, and ecstasy September of 2022, and then January 3rd and January 11th of 2023, that she also tested positive for methamphetamine on February 3rd of 2023, had not provided verification of performing any community service and was behind in her fees. And there was a looks like this officer, the officer said that, and were you the officer, sir?
No.
Okay, it was Miss Riggs.
Yes.
Okay, so Miss Riggs, it looks like had met with the defendant January 3rd of 2023 to address some of the violations, had held off making any recommendation until she could be seen for a substance abuse assessment. The assessment was done January 11th. Diagnosed having amphetamine use disorder, severe, cocaine use disorder, moderate, alcohol use disorder, moderate, other hallucinogen use disorder, moderate, and the recommendation of that was long-term intensive treatment. It says here that she voiced, the defendant, that being voiced her desire to do whatever it takes to be clean and sober, admitted she had an issue, and that there was a recommendation for safety. Obviously agreed to that, signed the administrative hearing. It looks like at that time, the probationer, Ms. Reynolds, also agreed to that. Mr. LeBlanc has now filed a motion for reconsideration or reduction of that sentence. So because there's some Hardin County cases that are pending is the issue. Is that correct?
Judge, that's one of the issues. I believe, from my understanding, and I may be wrong, she originally met with Ms. Posey, did the drug assessment, and she was under the impression that she was recommending the drop program. And then she came back, and that was when she met Jeremy Patton, who she'd never met before, and he's the one that told her it was safe fee. And in the midst of all that, she signed it without giving much forethought. She does have, and she does not want to go to state fee, goes over to state jail. She wants to, and originally she was trying to get into the Franklin house. And this case was pending, and then the warrant was issued. She does have those two Hardin County cases. My understanding is she would sit in this our jail until either Hardin County got her, or, I mean, I don't think state fee will take her with those pending.
So what's the status of the Hardin County cases?
I'm not on those cases, but they're still pending.
It was postponed. I had a court date on May 22nd, and my family called them and told them I was in Jefferson County, and they put it off. I don't know the next court date though.
Hardin County, not, it's one, people over there.
Are you on a bond? Are you on bond in those cases?
And those predated this case.
Yes, it's not a new charge.
So, I mean, our problem is that safety won't take her with those. And so we can do a couple of things. And I just found it all. Oh, it was.
I'll show you.
Okay. So, I mean, we can't just hold her here and she's on bond on those indefinitely. We've got to figure something out. So any ideas or suggestions? I mean, I can amend that, hold that in abeyance for now with some other sort of outpatient treatment, drug patches, whatever. I mean, I don't like it. It sounds like there's a serious issue that needs more than outpatient treatment. And so the problem is, Reynolds, what happens is I don't have much of a choice really, but to hold this in abeyance for now and let you go get those taken care of. But what I want you to understand is whatever I order on your probation with regard to outpatient treatment, at this point, you've got to get it figured out without intensive inpatient, which is really what you need. And so you can try to get in Franklin House or somewhere if that's, you know, you need to talk to probation. They can go over what the options are. I think at a minimum, JCDI needs to be ordered. Would you agree? Yeah. So what I'm going to do then is I'll hold that order of safety in abeyance. At this point, that means it's still ordered. It just means that you don't have to go right now. If you get out and you test positive, if you miss one appointment, if you don't start doing your community service, if you don't get a job and do everything you're supposed to, you're going to be right back in here. Safety may be an option. It may not be. It may just be that you go to state jail for up to 2 years. And so you need to take advantage of the opportunity that you're going to be given. I am ordering that you enter and successfully complete the JCDI program. Any other recommendations that probation has based on that substance abuse assessment, knowing that she can't go inpatient right now, then you're going to be ordered to do that. Without a hearing, I'm ordering it now. Whatever they say you need to do, then that's what you're ordered to do. Do you understand?
Yes.
I'm also going to make the order that obviously you can't make the court do certain things over there, but I want those cases cleared up as quickly as possible. So you need to get over there and get that figured out. Anything else that you can think of that I need to add, whatever you, based on this assessment, just send over whatever order and we'll get that taken care of. Okay. All right. Thank you. Release the safety hold. Yep. Whatever happened. Yes, ma'am. Yes, ma'am. Thanks, Todd.